Okay, Chair, I think we're ready to go.
All right, very good. We will call the meeting to order. And let me call the roll. Commissioner Baker.
Present.
Commissioner Bluestone.
Here.
Commissioner Carruthers.
Here.
Commissioner Castillo.
She's muted.
Celia, you're muted.
We're asking her to unmute.
Here.
Thank you. Okay, Commissioner Solomon
Present.
and Commissioner Villanueva.
Here.
And let the record show that the chair is present. First item, or the next item, I should say, is the approval of the agenda for today's meeting. Is there a motion and a second?
So moved.
Commissioner
Second.
Baker? Commissioner Baker?
So moved.
Commissioner, yeah, there's a motion and a second.
Okay.
I'm sorry. In favor, Commissioner Baker?
Yes.
Commissioner Bluestone?
Yes.
Commissioner Carruthers?
Yes.
Commissioner Castillo?
Yes.
Mr. Solomon?
Yes.
Mr. Villanueva?
Yes.
Chair votes yes, the agenda is approved. Next, is there a motion and a second for approval of the minutes of the October 1st meeting?
Move to approve.
Second.
Thank you. Any discussion? Hearing none, Commissioner Baker,
Yes.
Commissioner Bluestone,
Yes.
Mr. Carruthers,
Yes.
Mr. Castillo,
Yes.
Mr. Solomon,
Yes.
Mr. Villanueva,
Yes.
and chair votes yes. All right, we will now look at the gravamen of the agenda and go to item number 1 under commission meeting items, advisory opinion 2021-12. Jeremy?
Okay, thank you, Chair. Commissioners, this is an advisory opinion that marks the first time where the commission in an adjudicatory case issued some legal work product. In this instance, a jurisdictional determination on 2 administrative complaints that were filed during the legislative session in the beginning of 2021. 2 jurisdictional determinations were issued. Because of the State Ethics Commission Act, those jurisdictional determinations are confidential. But because the commission promulgated a rule that allows a commissioner to request that work product in administrative cases be converted into an advisory opinion, and after approved, published on OneSource, the rule enables the commission to convert its work product in confidential administrative cases into kind of precedent-setting advisory opinions, but shorn of all of the identifying information about the parties or the particulars of an administrative case. So it's a very smart rule. It enables the commission to, again, convert all of or the best work product that happens in administrative cases into advisory opinions. And this is the first time that that such an advisory opinion is before you. Commissioner Bluestone requested that 2 jurisdictional determinations in cases 2021-04 and 2021-08 be converted into this advisory opinion. So that's what we're looking at. The question presented, it's a really interesting one, and it's one that goes in a way to, I think, the core of what some of the debates of the State Ethics Commission Act and indeed the constitutional amendment. The question presented is, if an administrative complaint alleges that a bill, if enacted by the legislature, would result in personal benefits to a member of the legislature, and where the complaint further alleges that a member of the legislature violated the Governmental Conduct Act, either by introducing that bill or making comments related to that bill in committee or on the floor, or voting on that bill, does the State Ethics Commission have jurisdiction to adjudicate that administrative complaint? And unfortunately, the opinion opines that the answer is no. And that's because of the speech or debate clause of the New Mexico Constitution, which follows the federal Constitution and indeed the I think nearly every other state constitution in the Union, which creates and brings into American law this kind of ancient legislative privilege that, as it's phrased in the New Mexico Constitution, members of the legislature shall not be questioned in any other place for any speech or debate or for any vote cast in either house. And the reasoning of the opinion is that language, any other place, includes the State Ethics Commission. Article 5, Section 17 of the Constitution that created the State Ethics Commission did not also amend the speech or debate clause of the New Mexico Constitution, either expressly or by implication. And part of what this opinion also points at is that not all of a legislator's actions are insulated by the speech or debate privilege. Only legislative acts, so that's the introduction of a bill, the giving testimony or commentary on a bill in committee or on the floor, voting on a bill. Those are the things that are protected. But if a legislator somehow violates the Governmental Conduct Act through other action, engages in self-dealing through actions that aren't legislative actions, then this opinion counsels that in those instances, the State Ethics Commission would retain jurisdiction. So that's a quick version of the opinion and its reasoning. And Chair, I'm happy to entertain questions and present it to you for approval.
Okay, let's go ahead and take a motion and a second on it and then open up for debate. Is there a motion and a second to approve?
So moved. Second.
Okay, any discussion? Commissioner Baker,
No.
Commissioner Bluestone?
I think it's an excellent opinion, very well done. The only question that occurs to me, Jeremy, I'm just recalling this issue. Wasn't there a legislator who was charged with speeding on his way to a legislative session, and he claimed that this insulated him from being charged with speeding? And I think that the case was resolved that he was able to be charged with speeding. But did you happen to come across that in your research? Do you recall when you were looking at this?
I do recall coming across that particular case, and Commissioner Bluestone raises a good point that there is ample case law, federal case law, United States Supreme Court case law applying the speech or debate protection, as there is other state case law applying the speech or debate protection. And all of that kind of remains there for the commission to counsel going forward as the commission encounters future Governmental Conduct Act claims alleging self-dealing on behalf of legislators or legislative self-dealing. And so there is a body of case law for the commission to apply in figuring out whether or not this advisory opinion and the New Mexico speech or debate protection applies or doesn't apply.
Thank you.
Thank you. Commissioner Carruthers? Hey, Gov.
There we
No
go.
questions.
Thank you. Commissioner Castillo?
I have no questions.
Thank you. Commissioner Solomon?
No questions, Mr. Chairman.
Commissioner Villanueva?
No questions, thank you.
The chair has no questions. All right, that being discussion closed. There's a motion and a second. Commissioner Baker?
Yes.
Commissioner Bluestone?
Yes?
Commissioner Carruthers?
Yes,
Commissioner Castillo?
Yes.
Commissioner Solomon?
Yes.
Commissioner Villanueva?
Yes,
Chair votes yes, the motion carries. Thank you. Walker, the next item up is Resolution 2021-03, the Annual Open Meetings Act Resolution. This was yours.
Thank you, Chair and Commissioners. This is a pretty straightforward piece of business. Under the Open Meetings Act, the Commission is required to annually determine what is the most appropriate means of providing notice and format of its meetings. This resolution doesn't really deviate from the past practices, but the Commission is required to consider what notice is appropriate under the Open Meetings Act every year, and so here we are doing that. So I don't know if Becky or Jeremy wants to chime in with anything further on this. I don't think Becky is the resident OMA expert, but there we are. I'd be seeking a motion to adopt resolution number 2021-03, which is an Open Meetings Act resolution. In your
Thank you. Is there a motion and a second?
So moved.
Second.
Second.
Thank you. Any discussion? Anybody?
I wanted to point out one thing, Mr. Chairman.
Go ahead.
I just want to confirm, as we I think have discussed before, that we can't have discussions outside of a meeting of a quorum or more. So that's 2 Republicans and 2 Democrats is a quorum. But short of that, if the Republicans want to talk with even 1 Democrat, or the Democrats want to talk with 1 Republican, you're allowed to do that.
It would also make us unique. It's a joke.
Oh, in terms of having communication?
Right. Cross-party communications.
And I just want
Damn
to.
good one, apparently, too. Yeah. So,
But again, I have no quarrel with it. I like it. I think it's good for the public to be knowing that we are all operating in the open, but we can have at least some discussions preliminarily before meetings, as long as we're cognizant of that quorum limitation requirement.
right.
Yeah.
Go ahead, Walker.
Just to clarify on that point, Chair and Commissioner Bluestone, there is a prohibition against rolling quorums, and so I take your statement of facts to be that there is only going to be discussion with 1 member of the other party, and it's not going to be a situation where two Ds or 2 Rs have a discussion with 1 member of the other side, and then that member informs the other member of what discussions have taken place, because that would create a rolling quorum.
Right. Anybody else?
I would just point out that I'm neither a Republican nor a Democrat. So everyone can feel free to speak with me.
Thank you, Jeff. And on that note, we'll call the question. Commissioner Baker,
Yes.
Commissioner Bluestone,
Yes.
Commissioner Carruthers,
Yes.
Commissioner Castillo,
Yes.
Commissioner Villanueva, Commissioner Solomon, forgot you, sorry, Ron.
Yes. No problem.
And chair votes yes. Motion carries. Thank you. And the resolution is adopted. Okay, next, Jeremy, the annual report.
Sure thing. So commissioners, this is a draft of the commission's annual report for 2021. The commission has a duty to, under the State Ethics Commission Act, to submit this report by the end of each year to the governor and to the legislature. Under statute, we provide an update of what we've been doing in the past year, but also, and importantly, the commission provides its set of legislative recommendations going into the upcoming legislative session. And so this report, much like our report for 2020, does just that in draft form. And I'll just go through some of the highlights before turning to the legislative recommendations. So some of this is familiar from last year with respect to who we are and how we're organized and what the history is. I'll pass over that. I do want to touch on page 7 of the report, which is page 26 of the public meeting materials. This is the fiscal report. We've recently received approval from the state auditor's office to share our audit opinion for FY21. And the commission received from its CPA, Clifton Larson Allen, an unmodified opinion. That's the best kind of audit opinion you can have. There were no findings. And we received a complete clean bill of health with respect to the commission's finance and its audit. In a previous draft that you have seen, this information was redacted because the Office of the State Auditor has to approve it's being made publicly available, but they have done that, and so it's part of our fiscal report. This single page that kind of just presents the most comprehensive view, or I guess the most summary view of the commission's finances in FY21, kind of shows our budget position, how much the commission intends to revert our expenditures, and just kind of where we are fiscally. But the takeaway here is that we get to present to the legislature and to the governor that we've received an unmodified opinion. Okay, moving on. With respect to administrative complaints, the commission is doing about the same volume this year as we did last year. The commission is now up to, I believe, 26 separate administrative complaints filed in the commission's kind of quasi-judicial adjudicatory setting. And I think about 18 of those the commission has been able to close out, and there's still a couple of handfuls of cases pending that we'll be working through the end of this year and into next year. With respect to advisory opinions, the commission did a lot of work on advisory opinions in 2021. The commission has issued 12 advisory opinions. Those are now made available on OneSource. The statutory provisions, as we have discussed before on OneSource, are annotated with the commission's advisory opinions. And we've had opportunities to present on the content of these advisory opinions in recent trainings, and specifically with the 5 or 6 procurement code advisory opinions that the commission has issued. We've been able to share those opinions with the New Mexico Public Procurement Association, with the Department of Finance and Administration's local government division, with municipal attorneys, with folks in the counties. And so the commission's work on its advisory opinions is being publicized as best as we know how. With respect to the commission's civil enforcement and litigated matters, we're doing a lot of work there too, and we've done a lot of work there in 2021. The commission, as you know, participated as amicus curiae in the State v. Gutierrez cases. Those are the Governmental Conduct Act constitutional challenges to Section 3A through 3C of the Governmental Conduct Act. Those are very important cases for the commission, for the Attorney General's office, and for the Governmental Conduct Act as a whole. Those cases are set for oral argument on January the 14th, and the commission staff will help to prepare the Attorney General's office for those arguments. However, the Attorney General's office would like our help, but we're there to support the AG's position in those cases. Next, in 2021, the commission, you'll remember early in the year, we settled a significant Campaign Reporting Act case. That was State Ethics Commission versus Council for Competitive New Mexico. We filed that case in the second judicial district to essentially force this organization, CNM, to disclose how much money they had spent on advertisements that were related to the 2020 Senate Democratic primary and who their donors were. And the major disclosure that we forced was that this organization had spent over $130,000 in campaign-related advertisements to those Senate primaries, and that their donor was in fact P&M Resources. More recently, the commission has filed a civil action to enforce the revolving door provisions of the Governmental Conduct Act against a former Sandoval County commercial assessor and the property tax consultancy that that individual now works for, and that litigation is currently ongoing. And last, the commission's other litigated matters relate to the subpoenas that branch out of the investigations of commission administrative cases. The executive director of California's Fair Political Practices Division told me that in the first years, in the first decade of the commission's work, that the subpoena related litigation would form a kind of steady part of the civil litigation that the commission is involved in. She kind of warned me that subpoenaed parties will test the commission's subpoena power. They'll test it in district court, they'll test it on appeal, and it will take a good decade before those issues, that litigation gets kind of stable. And so we engaged in a couple of sets of subpoena litigation in 2021. That's totally normal, and we should expect it to continue, much as the Fair Political Practices California Fair Political Practices Commission suggested would happen. Next, in terms of trainings, we provided a slew of trainings in 2021, and the annual report goes through those trainings. We have a duty under the Governmental Conduct Act to provide Governmental Conduct Act trainings to everyone in the state to whom that statute applies, and that's pretty much everybody in government, state and local, school boards, special districts. It's a huge burden, and we cannot come close to carrying that burden without providing kind of presentations to affiliate groups, to support groups like the New Mexico Public Procurement Association, to attorneys for the counties, to attorneys for municipalities. Walker and Becky have done a great job in getting out and providing Governmental Conduct Act trainings to small municipalities, to smaller local governments that have requested the training. And Becky's done a great job in getting in front of a lot of the state board and commissions, both within the umbrella of the Regulation and Licensing Department and those boards and commissions that are outside of the umbrella of the Regulation and Licensing Department. So we do kind of try to keep our foot on the gas pedal with respect to providing trainings in a way that we're able to handle, given that we have 5 people working here at the moment. Next, with respect to the commission special projects in 2021, we had a couple of big special projects to carry as well. The first was the Citizen Redistricting Committee. This commission did an excellent job in interviewing and appointing the 3 members of the Citizen Redistricting Committee to that committee after they were formed, and as Justice Chavez kind of put that organization together. The Ethics Commission, we provided staff support to the Citizen Redistricting Committee on a interagency memorandum of understanding reimbursement basis. That contract was able to kind of keep Dr. Kiley with the commission for longer than he otherwise would have been, given our budget constraints. And that committee, the CRC, finished up its work in late October, and they submitted their draft redistricting plans to the legislature, and the legislature will start on the redistricting session on Monday. Another big project that we kind of carried out in 2021 was the special report that the commission had to put together for the governor, for the legislature on the commission's jurisdiction. And as you'll recall, we did a lot of surveys of local governments about their views of the Ethics Commission, about their views of what the commission could provide, about expansion of the commission's personal and subject matter jurisdiction. And as a result of all that research and all that discussion, the commission put together a special report where it made what I think were sensible recommendations for the expansion of its personal jurisdiction to include the agency entities, as well as the officials and employees for agencies and instrumentalities of the state. That will help with enforcement of the procurement code and will help with the commission's ability to see injunctive remedies through. And the commission also recommended the expansion of its subject matter jurisdiction to cover those constitutional provisions that are kind of core ethics constitutional provisions. So those were our kind of 2 big extracurricular projects, if you will, during 2021. And I'm proud to that the commission had got through both of them. And then finally, Chair and Commissioners, the legislative recommendations, what the commission is recommending in terms of legislative reform on the ethics laws. And in many ways, this is the most important part of the annual report. The first set of legislative recommendations kind of carries forward legislative recommendations that the commission made in the last annual report, but which were not picked up in legislation. And some of these ideas are imported from the thinking that New Mexico Ethics Watch has done about the revolving door between lobbyists and legislators. So the first kind of recommendation, which is just again rolled over from last year's annual report, requires a 2-year cooling off period between serving as a legislator and working as a lobbyist. Again, from last year, there's a recommendation that legislators, before voting on a bill, disclose whether or not their family member is lobbying on a bill on which is presented to them for a vote. And there's also the rolling forward of a recommendation to add transparency requirements for lobbyists and lobbyist employers about what bills they're lobbying on, the position that they take on those bills. And that was a piece of legislation that I believe last session Senator Steinborn was particularly interested in carrying. So those are a set of kind of lobbyist regulation recommendations that the commission is rolling forward from last year. Similarly, like the commission's recommendations from last year, the commission again is in this draft is recommending one small change to the Campaign Reporting Act that would create the requirement of a segregated bank account for independent expenditures and for the use of independent expenditure. This idea did get picked up in a bill that Senator Worth carried last session. It made it through the Senate and it even made its way to the House floor, but never got to the point in the last day of the session where it was called for a vote in the House. So we got very close with this idea last year, and so it's again here presented for legislative recommendations. Next, there's a set of recommendations that carry forward what the commission did in its October 1st special report. That's to amend Section 9A of the State Ethics Commission Act to expand the personal jurisdiction for the agency entities of the state and to add those constitutional ethics provisions in the New Mexico Constitution to the commission's subject matter jurisdiction. And finally, and Chair, I think there's one more recommendation here that is so large that it probably merits a kind of bifurcated separate discussion. That's the Disclosure Act. We've been working on a large project to kind of repeal and replace the Financial Disclosure Act with a statute that's much more useful. And so before turning to that, Chair, I'd like to kind of just entertain any questions about the foregoing of the annual report and then perhaps do the Disclosure Act separately.
Fine. Any discussion? Let me go through. Jeff, do you have anything?
I just wanted to ask Jeremy, I understand that yesterday you did a training for municipal lawyers. How did that go?
That's correct. That it went very well. The Municipal League had its kind of winter seminar. They had programming for city managers. They also had programming for the Municipal Attorneys Association, and yeah, and they invited us to present. The municipalities, by and large, are somewhat removed from the world of the commission, in that neither the municipalities as entities nor their officials nor their employees are subject to the commission's administrative adjudicatory process. But they do have obligations under statutes that the commission enforces, such as the Governmental Conduct Act. In some instances, if they're hiring lobbyists, the Lobbyist Regulation Act, and for the non-home rule charter municipalities, they're subject to the procurement code. And yeah, and so basically the presentation was to clarify how the commission interacts with municipalities and to run through some of those statutory requirements that do apply to municipalities and just to the clients of the municipal attorneys. I think it was well received, and the Municipal League is kind of one of the commission's partners in kind of presenting this law, particularly the Governmental Conduct Act and the Procurement Code. We present every chance we can with respect to the Municipal League.
Thank you.
Stuart?
Thank you, Mr. Chairman. Thanks for the excellent report, Jeremy. Very thorough, very well done. My question is on the proposed legislation. Do you think it would be helpful if we as a commission adopted a motion to have you write on our behalf to the governor to get a special message on these bills that we're recommending, and maybe put copies to both the Democratic and the Republican leaders of each house, because with a short session, these will not be germane without a message from the governor. And I just, I don't know what the status is, whether you've been in touch with Senator Worth, for example, about the segregated bank account one, or with Senator Steinborn about the lobbyist bill disclosure one. But I'm just wondering if it might be helpful, if you think, for us to adopt a motion to have the commission on record as requesting the governor to issue a message for these bills, and to let the legislative leadership know about that.
So Chair and Commissioner Blueston, I think that's a great idea, and I'm happy to draft it for the commission. I have not had conversations with legislators yet about these bills. The kind of work that we've been doing is still focused with some of the other executive agencies. So particularly with respect to the Disclosure Act, we've been in communication with the Secretary of State's office about that act and the Attorney General's office about the act. I know that the Attorney General's office and the Attorney General himself are very supportive of the Disclosure Act. And so part of the plan was to kind of get on the same page with some of the other significant executive agencies, and with that support, kind of go to the governor and request a message. I think that a message with respect to the Campaign Reporting Act, the segregated bank account, I tend to think that's the least likely of the recommendations to get a message this particular session. But I think there's a chance that the commission might receive a message for perhaps some of the lobbyist recommendations, and the best chance, I think, given the support of the Attorney General's office and what that office has been doing with respect to some governmental corruption prosecutions, I think we have the best chance with getting a message on the Disclosure Act. And so I would be happy to draft that letter for the commission.
If you don't feel like you need a motion to that effect, that's fine. And I thought we were going to talk about the Disclosure Act separately, but I think it would be good for there to be some follow-up on all of these recommendations in terms of communication to the governor and the legislative leaders of both parties, of both houses.
Agreed.
Thank you.
Thank you. Governor?
A couple of comments. One, looking at your roster of presentations, I do not see the legislature on that list. It would seem to me somewhat important for us to also give educational ethics training to the legislators. In my understanding, it's required of them anyway on an annual basis. Is there a particular reason that we're not participating with the legislature?
That's a good catch, Governor. The requirement is a semi-annual presentation that we're statutorily required to provide to the legislators. And ordinarily we do that in December of even numbered years. And but I take your point that, even though the statute requires those trainings every other year, it might be prudent for the commission to get in front of the legislature before every session. And that's something that I would need to speak with Raul Burciaga about, in terms of how the Legislative Council Service schedules trainings in advance of the sessions.
Mr. Chairman, Jeremy, I think it would inure to our benefit to be the go-to source for the legislature in terms of ethics education. For a variety of reasons, we probably have more to offer. But in particular, we need to be before the legislature doing these kinds of things in support of the program. On a second point, on the legislation on the, what do you call it, the merry-go-round or whatever, you recommend 2 years of abstinence from any participation under that particular piece of legislation. Have you run that by a number of people, and have you discovered that's probably going to be a lot of reluctance to passing such a piece of legislation?
Well, Chair and Governor, the 2 years is kind of anchored in some of the discussions that the commission has had on the model code of ethics. I do recognize that cooling off period might be aspirational, but I also think that it's maybe better for the commission to start with an aspirational position and let it be whittled down through politics, as opposed to starting with a more realistic position and then letting it be whittled down by politics. So that's a summary of the thinking there.
Well, I would agree with your strategy. I'm not opposed to the 2 years, but I think, knowing what I know about New Mexico legislators, that's going to be an uphill climb.
Yes, sir, I hear you.
Anything else, Gov?
No mas.
Okay. Celia Castillo?
I don't have any specific questions. I just want to say that the amount of work that's done by your staff, only 5 people, is amazing, and it's commendable. So thank you.
Thank you.
Thank you. Ron, anything?
No comments. I just want to also give some accolades to Jeremy and the staff for all the work that they do. Appreciate it very much. Excellent report.
Thank you.
Thank you. Our friend from Carlsbad, Miss Judy.
Wanted to say the same thing. I think it was an absolute delight listening to your presentation, even though it was just a partial presentation. It's amazing where you've taken the commission. You have an incredible staff working for you, and I've said you're Superman, and I think that your staff are superheroes, and I thank you for all the work you've done for us. You make us look like super commission.
Well, you are. Thank you.
Thank you, Judy. And thank you all. And I would echo that last sentiment. It is altogether too infrequently that I have not recognized the extraordinary job that Jeremy and the entire staff does. And so I want to make sure that does not go unnoticed by me as well. That having been said, is there a motion and a second?
Well, Chair, before you move to that, can I present the Disclosure Act?
Oh, that's the.
That's the last of the legislative recommendations.
I'm sorry, that's another. Yeah, I thought it was a separate matter. No, go ahead.
Okay, I appreciate that. So commissioners, in Appendix 1 to this report is a bill that we have styled as the Disclosure Act. As I mentioned, it's a repeal and replace of the Financial Disclosure Act. Very briefly, what this act is doing is requiring more and more deep disclosures from individuals who work at a high level in state government. That's folks that hold elected office, state agency heads, folks who are appointed to board and commissions, and they're subject to confirmation by the Senate, and folks that put themselves out to run for elected office, and then the two kind of other significant commissions that aren't confirmed by the Senate, the Insurance Nominating Committee and the State Ethics Commission. The current Financial Disclosure Act, from your experience in filing those, you'll know that the disclosures are not very demanding, either in terms of what you have to disclose about your position, your financial position, nor are they very demanding with respect to the level of detail at which you have to make those disclosures. So currently, if you and I as a head make more than $5,000 of an income source, we have to say that, and we have to say the kind of general category description of the source of that income. And that's pretty much as demanding as the current Financial Disclosure Act gets with respect to the really significant part of our respective financial positions. The current Financial Disclosure Act does not require disclosure of assets. It doesn't require disclosure of liabilities, of debts that we owe. It does not require disclosure of gifts. It doesn't require disclosure of business organizations in which we have ownership interests. And what's going on with this act, this draft, is it remedies all of that. This act is based primarily on the American Law Institute's principles of law with respect to disclosure. The ALI is one of the most respected kind of organizations with respect to both the codification of the common law and certain other statutory law. And so the ALI have been working on principles for ethics law over the past half decade or more. And part of what they've been working on, and we've been watching in their tentative drafts, is work on disclosure. And so some of the ideas in this document pull from ideas from the American Law Institute. Other ideas pull from discussions that we've had with Ethics Watch and others in the advocacy community about the Disclosure Act. So very quickly, what this statute, this bill, this legislation does is it requires disclosure of assets north of $50,000. It requires disclosure of income, specific income sources north of $600, which puts it on par with our federal tax reporting obligations. It requires disclosure of liabilities. It requires disclosure of gifts. It requires disclosure of business entity relationships. It requires disclosure of professional licenses, like the current act, and it requires disclosure of business interactions that we have with public agencies. Because this act is more demanding in terms of disclosure, there are elements at the end of the act with respect to records and the ability for folks to ask for records requests as to this information. And one of the provisions in this act is if someone was to make a written request for these disclosure statements to the Secretary of State's office for an individual who's not an elected official or not a candidate for elected office, then the Secretary of State's office has to inform the filer of the disclosure statement that someone is asking for their records. And that's in contemplation of folks using this statute and IPRA to kind of investigate their divorce proceedings or for other kinds of interests that might be separate from the kind of ethics purposes of a disclosure regime. And finally, the kind of remedial provisions of the current draft that you have before you kind of put this Disclosure Act on par with the remedial provisions of the Campaign Reporting Act. And on Monday afternoon, Walker and I are meeting with the head of criminal in the Office of the Attorney General to get a sense of their view of the bill and also their view of the criminal remedial provisions in this bill. So that's the Disclosure Act. And if I was remiss in missing any of the big pieces here, I'm certain that Walker could fill in. But it's presented to you as part of the annual report to kind of continue to work on and present to the legislature and the governor once we're done.
Thank you. Any discussion on that last section? Yes, Stuart?
Thanks, Mr. Chairman. Jeremy, I like the bill. I'm curious about a couple of the features in it. And you talked about the American Law Institute as being a source, but there are two main financial disclosures as I read this. One is any asset of more than $50,000 that's owned. And I assume that means that if you have more than $50,000 in a big fund or a financial management company like Fidelity or Charles Schwab or something, you still have to identify any particular companies, any particular assets within that you have more than $50,000 in. On that point, am I reading that correctly?
The language in the bill currently is that if the investment is or forms part of a fund, the reporting individual need only identify the fund and the fund manager and not the underlying holdings of the fund. So, for example, if you held more than 50,000 of, Vanguard, All World, FTSE, exclusive of the United States fund. And you would need to disclose that, the bill would require you to disclose that you hold more than $50,000 in that particular fund, which is managed by Vanguard. But if your holdings in that fund were so large that you in fact held, as through holding that fund, more than $50,000 in HSBC, which, let's posit is the fourth or fifth, largest stock in that fund's portfolio. In that hypothetical, number one, congrats, and number two, I don't think that the bill would require the disclosure that fund is so large that you in fact have 50,000 in HSBC.
I read that the same way, but if you have a bunch of ownership interests, stock ownership in individual companies that are all in your Charles Schwab account or your Fidelity account or your Vanguard account or whatever, you would still have to disclose each of those companies. As I read this.
So thanks for clarifying that. Yes, if you're using a brokerage account held by an investment house, and in your brokerage account, you not only have funds, mutual funds, ETFs or whatnot, but you also have shares of individual companies. I think that the bill would require disclosure of the holdings of those individual companies, their stock, if they're held outside of a fund, but within a brokerage account.
That's how I read it too. Thank you for that clarification. And in terms of the source of income of $600 or more in a year, whether it's earned income or unearned income, how did you come up with the figure of $600? Why wasn't it a round figure like $500 or $1,000? And again, that's talking about dividends, real estate investment returns, that kind of thing.
This was a very clever idea that originated with Walker, so I'm going to let him answer it.
Thank you. My understanding of IRS reporting rules for earned income, either as a on a 1099 or as a W-2, is that the reporting requirement for an employer or a I guess the contracting entity is triggered at $600. So I think some objections are raised to lowering. I think this was a concern with past iterations of the Financial Disclosure Act. Some concerns are raised with smaller income amounts that people might inadvertently fail to disclose something because they just didn't remember getting paid, $800 for the couch they sold on Craigslist or whatever. And so the $600 number is meant to basically require disclosure of income that would ordinarily be disclosed on a Form W-2 or 1099. And so in theory, you should be getting these forms in the mail. There's less of a concern there that you might be missing something inadvertently. So,
Well, at least there's thank you for that explanation, Walker. I wasn't aware that there was that IRS trigger of the $600. That makes sense, the way you explain it.
Thank you. Anybody else?
I have a couple of questions.
Yes, Judy.
I'm listening to what it is that's going to be required on this report. And it just seems to me like it's going to be a nightmare to do. I mean, to complete, in some cases, some people might require the help of a CPA or portfolio manager or a wealth manager to complete them. It's actually a requirement of a lot of information. I don't know what the consequence of missing some of that information would be, but it to me sounds like a lot of work. I have a question about the assets. So I'm assuming that when you're talking about assets, you're talking about anything over $50,000, i.e. a car, farm equipment, et cetera, that eventually depreciates. So you're going to have to follow a depreciation schedule. Would it include something like that?
Commissioner Villanueva and Chair, the bill doesn't include the requirement as to the identification of assets at that level of detail. My first reaction is with respect to the depreciation of assets. This bill does include a rulemaking, a delegation of rulemaking to the Secretary of State's office. I think that ordinarily, some of the function of delegated rulemaking under statutes is to kind of clear up some of those details as they arise. I think that the most honest off the cuff answer I could give you with respect to your question is if, year by year, these financial disclosure statements would be required annually. And, if the asset depreciated, to a point where it was now worth less than $50,000, you banged up your Ferrari, driving it around Carlsbad, you wouldn't have to disclose it that year because it's no longer an asset that's worth $50,000. But that's again my kind of off the cuff answer. The statute requires identification of assets worth $50,000 as of January 1st of that year, and if they depreciate below that, then they're no longer worth that amount. And if there are more complications, which I'm sure there are, that's why we've provided for rulemaking. To your larger point that this requires a lot, it does require a lot, but that's also because the current Financial Disclosure Act is not particularly helpful, and to some extent we consulted the disclosure requirements that are placed on members of Congress, and they, the federal government has done a good job with respect to kind of putting guides around the financial disclosure requirements that are incumbent on Congress people. And, I think, state legislators, are really no less competent in terms of being able to comply with similar disclosure requirements. And our agencies shouldn't be any less competent in terms of putting that information together in terms of guidance for how to comply. But to your larger point, yes, this requires more in the way of disclosure, more in the way of operations. It's, thinking operationally. The Secretary of State's office has already indicated that they would need more in the way of resources to effectuate this. And frankly, the Ethics Commission would need more in the way of resources to enforce it. But it's a start.
Thank you.
Can I just add one quick thing that very briefly, the one major shortcoming of the current statute is it does not require lawyers who represent clients in front of state agencies or courts to disclose who their clients are, even if that disclosure is made to the state agency or the court. And, that is one big part of legislators' private affairs that is outside of the scope of the Financial Disclosure Act, and that this act would remedy and require disclosure of clients. And that's just one thing. I know Jeremy mentioned earlier other points to cover, and that is one of them. So sorry for jumping in there.
Thanks, Walker.
Okay.
Thank you.
Yeah, I've got a question. What is the universe of people this would apply to?
Commissioner Baker, did you ask the universe of people?
Yeah,
Okay, it's roughly the same as the current universe, shorn of a kind of vagary in the current statute. So the universe is essentially all elected officials. I believe in the executive or legislative branches of government, all candidates for those elected offices, all state agency heads, and the commission has issued an advisory opinion opining on who is and isn't a state agency head. And that's essentially, if you're the head of a state agency that receives an annual appropriation, either in Section 4 of the General Appropriations Act or in the feed bill, you're a state agency head. And a board member or commissioner who is confirmed by the Senate. That's roughly the universe of folks that are would be subject to these provisions.
so it would not apply to judges?
Walker, correct me if I'm wrong, but I do not believe this applies to judges.
I think as with current law, it would apply to Court of Appeals and Supreme Court judges who are candidates in an upcoming election. So who've had to register under the Campaign Reporting Act as candidates, but not incumbents to those offices.
Unless they're candidates.
Unless they're a candidate again, I guess for a retention election, they would have to file for that year.
But not district judges?
No.
Do you know why that distinction exists?
I do not know the origin of that distinction in the current law. And the scope of application is essentially brought forward from the current law.
And members of this ethics commission would be required to abide by this new Disclosure Act, assuming that it passes.
As would its executive director.
Thank you.
Okay.
I have another question, if I may.
Sure.
Are there two levels of disclosure? One for those who are at the highest levels of office, or elected office, I believe, that is how you expressed it, and those who hold offices that are non-elected or appointed.
So Chair and Commissioner Villanueva, that's a good notice of part of what's going on in this statute. There are not separate disclosure requirements. If you fall within the scope of application, then you have all of the disclosure requirements incumbent upon you. There is a difference in this bill about whether or not you receive notice if someone is requesting your financial disclosure statement from the Secretary of State's office. And that distinction is if you're an elected official or a candidate for statewide elective office, then the Secretary of State's office is just going to, have your financial statement publicly available. But for other folks that are required, state agency heads, ethics commissioners, board members and commissioners subject to confirmation by the Senate, those folks, their financial disclosure statements are publicly available, but upon request. And if a request is made for those statements, this bill requires the Secretary of State's office to inform the filer that someone has requested their financial disclosure statement. That's the difference in this bill between how it applies to elected officials and candidates for elected office and the universe of other folks that it requires disclosure from.
Thank you.
Any other discussion on that matter? Okay, Jeremy, I think it makes sense to maybe take up this beast one section at a time for approval.
Okay.
The first being approval of the annual report, and the second on the legislative session, and maybe a completely separate vote on the last matter, the Disclosure Act. Does that make sense to you?
It does.
Okay. I don't like that tone of surprise in your voice, but I'll accept it. Okay, so a motion and a second to approve the issuance of the Commission's 2021 annual report.
So move.
Second.
Okay, any more discussion on that? If not, Commissioner Baker,
Yes.
Commissioner Bluestone,
Yes.
Commissioner Carruthers.
He's away.
Yeah, it looks like it. Commissioner Castillo,
Yes.
Commissioner Solomon,
Yes.
Commissioner Villanueva,
Yes.
chair votes yes. Is the gov back yet?
This screen looks frozen.
I think yeah.
Yeah, I think he may have stepped away, but at any rate, it passes and we'll show him as not voting, which we can circle back around procedurally if you want to. But anyway, the motion carries. All
There's the
right, well, Gov, you okay?
I'm sorry.
Your vote was, the motion in a second was to adopt the issuance of the Commission's annual report. We're going to divide up these votes. This is just the issuance of the annual report.
And you voted on that in my absence?
Right. Everybody else has voted in the affirmative, but
I would vote in the affirmative.
thank you. Okay, the motion carries unanimously. Second is the discussion of the upcoming legislative session. And again, we are separating out the Financial Disclosure Act. That's going to be a separate vote. So relative to that, is there a motion and a second?
Move to
To
adopt the legislative proposals?
Second.
Okay, any other discussion? Hearing none. Commissioner Baker,
Yes.
Commissioner Bluestone,
Yes.
Commissioner Carruthers,
Yes.
Commissioner Castillo,
Yes.
Commissioner Solomon,
Yes.
Commissioner Villanueva,
Yes.
chair votes yes. Motion carries. All right, and so finally is the proposed Financial Disclosure Act. Is there a motion and a second?
Move to adopt?
I'll second it.
All right, there's a motion and a second. Any more discussion?
My only comment is that shocked if this passes in the next session. But this obviously is going to be a topic that is going to be debated for quite some time.
My suspicion is the over-under is maybe a little longer than one session, but your point is not lost. Your vote, Jeff?
Oh, I'll add
Yes.
one technical comment before we vote on it. For you drafters, Walker, Jeremy, I think it might be a good idea when you talk about that $600 threshold issue to tie it into whatever is required by the IRS for disclosure of income sources, because that could change over time too. Just a technical point that I wanted to bring up. But are you asking for the vote, my vote, Mr. Chair?
I'm asking you, look, I need to go back. I was looking for more to close off discussion. If that's the end of it, that's fine. Calling the question now. Commissioner Baker,
Yes.
Commissioner Bluestone,
Yes.
Commissioner Carruthers,
Yes,
Commissioner Castillo,
Yes,
Commissioner Solomon,
Yes.
Commissioner Villanueva,
Yes,
and chair votes yes, unanimous. Okay. Thank you very much. Do we need to take a break before we go into closed session, or shall we press through? What's the preference?
let's take a break.
There you go. You're the consensus. All right. While Walker is magically making people appear and disappear. we'll
Wait,
be talking
before,
about-
Chair, before we do that, you need a motion to go into executive session and then maybe we'll take a break.
Good. All right. Well, see, I had one good idea today. So, all
moved.
right. Is there a motion? There's a motion. Is there a second?
second,
All right. No discussion. Commissioner Baker,
Yes.
Commissioner Bluestone,
Yes.
Commissioner Carruthers,
yes.
Commissioner Castillo,
yes.
Mr. Solomon,
Yes.
Mr. Villanueva.
Yes.
Chair votes yes. We'll move into executive session, and I'll see you after a brief recess.
Appears we're just waiting for Commissioner Bluestone. Oh, here he is. All right, we're back from closed executive session. And I guess before we proceed to item number 7, and in anticipation of public comment at the end of today's meeting, if anyone who is interested in making a public comment could please go ahead and raise their hands so we don't have to wait to see if there's any interest at the end. That'd be great. Thank you.
Great. And with that, Chair, I think we're ready to go. And I believe that Commissioner Bluestone has a motion for administrative case 2021-12.
Thank you.
I understand folks are not able to unmute themselves. Here you go.
Can you hear me okay?
Yeah,
Yeah.
I apologized. I prevented unmuting when we were in closed session.
That's okay.
You're good now.
I move to grant the appeal and remand with instructions to the General Counsel to investigate for violations of the Governmental Conduct Act and the Procurement Code.
Is there a second?
A second.
Okay. I assume no further discussion, but while I'm calling the vote, you can correct me on that. Commissioner Baker,
Yes.
Commissioner Bluestone,
Yes.
Commissioner Carruthers,
Yes.
Commissioner Castillo,
Yes.
Commissioner Solomon,
Yes.
Commissioner Villanueva,
Yes.
and chair votes no. The motion carries. All right, thank you. Next matter.
Okay, thank you, Chair. Commissioners, in administrative cases 2021-017 and 2021-020, the commission staff would ask for a motion to extend the investigatory period under Section 11B of the State Ethics Commission Act.
Is there a motion and a second?
So moved.
So moved.
Thank you. And the discussion, Commissioner Baker,
Yes.
Commissioner Bluestone,
Yes.
Commissioner Carruthers,
Yes.
Commissioner Castillo,
Yes.
Mr. Solomon,
Yes.
Commissioner Villanueva.
Yes.
Chair votes yes. Motion carries. Next.
Okay, thank you. And just to clarify, that was under Section 11A, not B of the State Ethics Commission Act.
Correct.
Next, Chair and Commissioners, the staff would seek a motion to dismiss administrative complaints 2021-23 and 2021-24 because the Secretary of State's office has certified voluntary compliance and they're subject to dismissal under Section 11934.3 of the Campaign Reporting Act.
Thank you. Is there a motion and a second?
So moved.
Second.
Thank you. Commissioner Baker,
Yes.
Commissioner Bluestone,
Yes.
Commissioner Carruthers,
Yes.
Commissioner Castillo,
Yes.
Commissioner Solomon,
Yes.
Commissioner Villanueva,
Yes.
and chair votes yes. Motion carries. Thank you.
Okay, thank you. And finally, Commissioners, on administrative complaints, on administrative complaint number 2021-25, the staff would seek a motion that the commission dismiss this complaint for lack of subject matter jurisdiction.
Motion second.
Second.
Is there a motion? I didn't hear.
I'll
Also,
move.
Thank you. Commissioner Baker,
Yes.
Commissioner Bluestone,
yes.
Commissioner Carruthers,
Yes.
Commissioner Castillo,
Yes.
Commissioner Solomon,
Yes.
Commissioner Villanueva,
Yes.
chair votes yes. Thank you. Next item.
Okay, thank you, Chair and Commissioners. On item number 8, resolutions related to civil enforcement actions. At this time, I would ask the Commission for authorization to authorize me to send a demand letter to the Curry County Republican women to comply with their obligations under the Campaign Reporting Act.
Motion and a second.
So moved.
Second,
Thank you. Moved and seconded. Commissioner Baker,
Yes.
Commissioner Bluestone,
Yes.
Commissioner Carruthers,
Yes,
Commissioner Castillo,
Yes,
Commissioner Solomon,
Yes.
Commissioner Villanueva.
yes,
Chair votes yes. Thank you. Motion to issue the letter carries. That's it, right?
Yes, sir. You're on to item number 9.
Okay, thank you. Next meeting, and as far as I am concerned, we have a pretty good streak going. Does anybody see the reason to deviate from our every other month first Friday for February of 22? Okay, then whatever that
Probably
is.
be out of the country then, but I think I can join in by Zoom anyway.
No, you may not be out of the country.
Well, yeah, if this variant, who knows what's going on, but I'm scheduled. to
Exactly.
be gone.
But yeah, okay, so we'll do that. And Stuart, if something does come up, if we need to consider, just give us a little heads up and maybe we can find it in our hearts to accommodate your many travels. Okay, so otherwise the first Friday in February, which escapes me at the moment.
Is the
That's
4th.
The 4th, thank you, that's the meeting. Public comment, Walker, I'll leave that to you to drive.
All right, thanks. Again, folks who want to make a public comment should use the raise hand function in Zoom. I think it's *9 if you're attending by phone, but it looks like everyone's on their computers or their iPads. The only person who's indicated a desire to make public comment so far is Mr. Tony Ortiz. I'm asking you to unmute yourself and see if I can ask you to start your video there too. All right, welcome, Mr. Ortiz.
Thanks, Walker. Just two things, Mr. Chairman, Commissioners, Jeremy, and your staff. I can't say how utterly impressed I am by the thoughtful, civil, and professional manner in which the State Ethics Commission operates, and I'm particularly pleased by the legislative recommendations that are included in the 2021 annual report. Those recommendations reflect tremendous amount of work by a lot of people over a long period of time, and to have the weight of the commission behind them is really heartening. Finally, hope everybody has a peaceful and safe and healthy holiday season. Thank you.
Thank you, Tony.
Mr. Chairman, I just also want to thank Tony and Kathy Sabo and New Mexico Ethics Watch for all their hard work and input into particularly the Financial Disclosure Act recommendations, but really a lot of others that they've done, and your work is much appreciated. So thank you, Tony.
Walker?
I believe that is it. I do not see anyone else has raised their hand.
Okay. For me, it looks like the last remaining item is to call the meeting adjourned. And unless there is strong opposition, I would so declare. Everybody have a great holiday season, end of the year. Godspeed on all of our various medical recoveries, and see you next year.
Sounds great.
Thank you very much.
thank you.
Thanks,
Everybody be safe.
You too. Bye.